Have you been sued by a debt collector and you don't know what to do next? The truth is, not responding is the absolute worst mistake you can make. In this video, I'm going to show you exactly how to draft a winning answer to your debt collection lawsuit, what to include, what to avoid, and how this one document can be the difference between an automatic loss and actually having a fighting chance to defend yourself. Hi, I'm Mike Ziegler, a bankruptcy and debt defense attorney here in Florida. For over 15 years, I've helped everyday people get out of debt, deal with collection lawsuits, and rebuild after unforeseen circumstances. If you need to speak with an attorney you can trust, please give me a call at 727-538-4188. Now, let me show you why filing an answer is absolutely critical and exactly how to do it the right way. What happens if you don't file an answer? Well, when you get sued by a debt collector, the court sends you a complaint and a summons. That summons tells you how many days you have to respond. In Florida, you typically have 20 days from the date you are served to file the answer with the court. If you don't file an answer, particularly in county or circuit court, within that time frame, the court can enter what's called a default judgment against you. What that means is that the debt collector wins automatically. They get everything they asked for in the lawsuit, the full amount of the debt plus interest, court costs, attorney's fees. Once the judgment is entered against you, that creditor can garnish your wages, levy your bank account, and put a lien on your property, notwithstanding the homestead exemption. Your judgment stays on your record and can follow you for years. So what if you want a chance of defending yourself or negotiating a better settlement, or even getting the case dismissed? You must file an answer and you have to do it on time. Now, let me walk you through exactly what you need to do. So first, when you get served with a debt collection lawsuit, you're going to receive two main documents. The first is the complaint. This is the actual lawsuit, and at the top, you'll see the name of the company suing you, and that's called the plaintiff. Below that, you'll see a list of names as defendants, or maybe just one name. There will be a case number, which is important because you'll need that to reference on every document that you file. Then the complaint is going to have a series of numbered paragraphs. These paragraphs contain allegations or claims that the debt collector is making against you. It might say things like you entered into a credit card agreement with Capital One, or that you owe a specific dollar amount for goods and services purchased. And then the second document is the summons. That's the paper that tells you how much time you have to respond. In Florida, in county court and circuit court, you typically have 20 days from the date you were served to file your answer. And that is 20 calendar days, which means weekends and holidays count. Unless the final day is a weekend or holiday, then it rolls to the next weekday. The response process is a little bit different in small claims court, where you don't have a response deadline, but a pretrial conference. So this discussion is mostly focused on county and circuit court cases. The summons will also tell you where to file your answer. It'll have the court's address and information right on it. Make sure you pay attention to that deadline, because if you miss it, you could lose by default. So here is where most people mess this up. There are two biggest mistakes that most people make. The first big mistake I see all the time is that people try to tell their entire life story in the answer. They'll explain that they lost their job, their medical bills piled up, and that they've been doing their best to pay but just can't afford it right now. The court doesn't want to hear that in the answer. That's not what this document is for. There will be a time later to present your side of the story if the case moves forward, but the answer is not the best place for it. The second mistake is trying to negotiate or make a settlement offer in the answer. People will offer to settle the debt for a reduced amount paid over time. Again, wrong document, wrong time. The answer is not where you negotiate. That comes later. So what should you actually put in your answer? Here's what the court wants you to know. Do you admit or do you deny the allegations in each of the numbered paragraphs of the complaint? That's it. That's really the whole purpose of the answer. So for each numbered paragraph in the complaint, you're going to give one of three responses. You can admit the allegation, you can deny it, or you can say that you lack sufficient information to admit or deny it, and therefore you deny it. So let me give you some examples of how this works. Let's say paragraph 5 of the complaint says you entered into a credit card agreement with Capital One Bank. If you know you had a Capital One credit card, you probably should admit that paragraph. Be honest, don't deny something that's clearly true. But here's where it gets important. Let's say paragraph 10 says that you owe a specific sum, like $4,234.89. Now, Now, unless you know that that exact amount is 100% accurate, it may be appropriate to respond by saying that you lack sufficient information to admit or deny that allegation, and therefore you deny it. You want to be honest, but that doesn't mean falling on the sword of an allegation that you don't know to be true. You're just being accurate about what you actually know versus what the debt collector is claiming you should accept as true. Here's another example. Let's say the lawsuit's filed by a junk debt buyer like Midland Funding or Portfolio Recovery. One paragraph might claim that Capital One assigned the account to them. Unless you have a copy of that assignment agreement and you can verify from your own knowledge that it actually happened, you would likely say that you lack sufficient information to admit or deny that allegation, and therefore you deny it. Do you see how this works? You're just making the debt collector prove their case, and if you don't have independent knowledge that something is true, then you don't have to necessarily admit that allegation. For most of the numbered paragraphs in these lawsuits, your response is going to be one of three things: admit, deny, or lack of sufficient information and therefore denied. No life story, no settlement offers, no explanations, just a straightforward response to each paragraph. Once you've drafted your answer responding to each of the numbered paragraphs in the complaint, and you may assert affirmative defenses if those affirmative defenses apply, you then need to file it with the court. And here's exactly how you do that. First, you're going to make 3 copies of your answer, 1 original and 2 copies. Next, you're going to take all 3 copies to the courthouse. The address of the court will be listed on the summons that you receive. When you get to the courthouse, you're going to go to the clerk's office. You're going to file the original with the clerk. Usually there would not be a filing fee unless you're filing counterclaims. And in most Florida courts, the counterclaim filing fee is going to be around $150 to up to around $400, but it can vary. And then ask the clerk to stamp the 2 copies with the dates and times that you filed. The stamp proves that you filed your answer, which is important. So if there's ever a question about whether you met the deadline, now you have that documentation. Now here's the critical part that a lot of people miss. You need to mail one of the stamped copies to the attorney for the debt collector. Their name and address will be on the complaint, usually at the very bottom of the allegations. Also is often on the summons. The court does not mail a copy to the debt collector's attorney. You have to do that yourself. If you don't send them a copy, they can claim that they didn't receive your answer, so you want to avoid that. So mail 1 stamped copy to the creditor's attorney. I recommend sending it by certified mail so that you have proof that they received it. That's the whole process. Draft your answer, file it with the court, pay the filing fee if it applies, get your copy stamped, mail 1 to the creditor's attorney, and keep 1 for yourself. Once your answer is filed with the court, everything changes. First, the debt collector can no longer get a default judgment against you. The automatic win is off the table. Now they actually have to prove their case. They have to provide evidence. They have to show up to court. They have to demonstrate that you actually owe the debt, that they have the legal right to collect it, and that the amount they're claiming is accurate. And here's what's interesting. A lot of debt collectors, especially junk debt buyers, may not have all the documentation they need to prove their case. They often buy these debts in bulk for pennies on the dollar, and sometimes the paperwork doesn't come with it. Filing your answer forces them to prove their case or to walk away. Filing the answer levels the playing field. It forces the debt collector to actually do the work of proving their case, and in a lot of situations, it's enough to get a much better outcome than you would have gotten if you did nothing. Now, I know this process can feel overwhelming, especially if you've never dealt with the court system before. If you're in Florida and you need help with this, my office handles these cases all the time. We can review your lawsuit, we can file an answer, we can make sure that this is done correctly and on time. So if you're being sued by a debt collector and you're not sure what to do next, don't wait. Call us at 727-538-4188 for a free consultation. We'll review your lawsuit, explain your options, and make sure you file your answer correctly and on time so that you don't end up with a default judgment. And if you want to learn the next critical step after filing your answer, including how to use arbitration and force debt collectors to back down, watch this video next. I'm going to show you exactly how to win a debt collection lawsuit using answers and arbitration strategies that can completely change the outcome of your case.